Even with Trump?
Do you know, he's too young, he's 15 and 16 years old. He's 15 and 16 years old from that. The first job, as soon as shortly after writing my house was back on. They all
He's not a healthy person.
They're saying, no.
There's some real mental health issues.
No, I cannot understand. His sons look perfectly sensible.
Yeah, his children are relatively impressive. Some people did something right.
And how come
They're obviously their mom. Yeah, because the kids are.
and they're supposed to be close over advising.
Oh, you know the kids are all have to. But George Holding, in contrast, he's just plain a mean person. He really is. And he picks on the weak and those with problems. That's not a great word.
I wasn't.
No, but he picks on folks with problems. Yes, it's anybody doesn't know my dog's name. A single mom, blind child, overworked already. We're going to jump on her.
And over.
Big time.
Here's my favorite story of George Holden. When we were doing the depositions on my email, we went through every new hire that was made under him. And every new hire was a white man under the age of 40.
Or a member of the junior league. There were a couple of those.
At that point, only
Kelly Perry.
yeah, she had just come on. She was going to be last long. And so we're going through, we get to mid-era. And so the pattern has been established by the time we get to Eric that it's a white male under 40. And George is sitting there. When God says to him, age, he was 38. Race, and there was this dead silence. Even the court reporter looked up. And I mean, it was just all sad. Like, even their attorney. And he goes, oh, perhaps that's not a race.
This man was really U.S. Attorney?
He's now a congressman, yeah.
He was the U.S.
Oh, wait a minute. George said that.
Yeah.
Oh, my
George
God.
Holden said that.
Oh, my God. If he's stupid,
Yes.
he really is. He really is.
But he's also mean-spirited.
Yes.
Very mean.
He would walk up and down the hall, as Pete Cohen said, as if we were treated us like we were a bunch of terrorists. He wanted us at our seats at the end. And he worried us. He did not want anybody talking to anybody else. People would stop me at his office. And 9 times out of 10 it was, I have this type of case, or I've got a case against so-and-so, or Judge so-and-so said, hey, you're talking, you're working, you're bouncing ideas. What's going on here? Get back to your offices. He was a real guy.
And he was, which Bush, I assume, Bush too, yeah.
Of course, Jim got in this argument about whether or not we were shits or little shits.
Yeah, George and I are not.
Yeah, and he just beat Renee Elmer, and she's not any good, but God, that's actually what he is.
She started to look at the art.
That's what I thought.
But it's very interesting how he learns his character. You never see him. You never hear him. There was one debate, and he did terribly. It was just, nobody watches us up in Jordan. It's not a high level debate. has not come across yet. And so his whole approach is, and I say no. He doesn't say what he is for. He always says, I say no. That's his whole.
Gadsden's convinced George could have been Russian. Gadsden says, I don't care how many wives and children you have. Trust me. I respect Gadsden's judgment.
And after you won, you couldn't really go back to work. I mean, you could have.
The settlement agreement was that I would not apply for personal loans. That was fine. What else? But I did get little things. I did all this. In the settlement agreement, there's talk about, what would you do if somebody wanted to reference. And I worked with my lawyer very hard on this and said, I don't want to do any George Holmes, any they can only talk to HR. We wrote out what HR said, and they agreed. And that there was that these specific people could not say anything about and then the news insurance. Very nice. My lawyer said, talk to the press. Are you allowed to do that? So they were very upset about it. You gave them interviews or something. So no, the settlement agreement says they can talk. And my lawyer looked at me, excuse me, God, I'm purpose to do
I may catch this on the evening news.
Oh.
She's meeting our grandchildren who go all around Sunday. 10 and 12. No, she's going on Raleigh. I'm going to I got to be in Fort Newell tomorrow. How bad? What do you mean? I've been asked to prepare a list of 200 several judges. It did not occur to me to put my name. He bothers that judge. So, Mike Barton. Well, I gave Bill Clinton every opportunity to put me on the circuit. Bad stuff every morning. But we didn't, we never got the big bucks out because we didn't have them.
I have to go. I know.
Yeah, I'm gonna catch this on television. I gotta go And most of we came to meet the Banshee sisters anyway, and they aren't even here. I think that's good that they're not here. I think somebody told them, you won't enjoy it. You won't enjoy it. Don't bother. Happy to do it. You get together with them nicely. Good to see you, friend. Don't you think this is dangerous?
Yeah, you too. Good luck.
I'll catch this on the Yeah, I got a good story.
Yeah, go over hours.
Well, how much talking about here? No.
What it makes it, doesn't it? Makes a huge difference.
And that's what it's
Somebody was like, yeah.
All right. Oh, yes, it's Officer Spirit Court for the County of Durham.
Should I do that?
Is now sitting and ready for the dispatch of this witness, and Honorable Leonard Hudson, Judge, presiding United States State Honorable Court. You may be seated. You have a cell phone, which is turned off or put on vibrate. While court is in session, remain in place. Good morning, Your Honor.
Good morning. So. Thank God we have grand juries. Spent an hour of my time there. Ladies and gentlemen, why are we here today?
Good morning, Your Honor. Mary Jude Darrow on behalf of Michael Peterson, and I think
Obviously, I meant that to be responded to by the party with the burden of proof. So would that be you?
Mr. Dornfree thought it was me, and I had assumed it was me, so whichever way you wish, Your Honor.
Yes.
Either way, I think both of us are prepared.
All right.
Your Honor, I believe, in speaking with the clerk, that you have the court files. Specifically, we're dealing with 01 CRS 24821. And it's my understanding that we are here today to address 3 of the motions filed by the defense. And in speaking with counsel beforehand, certainly leave it up to their discretion which one they wanted to address first, which I believe was the one dealing with the evidence within the custody and control of the clerk's office. Is that correct?
That is correct, Your Honor.
All right. And tell me how you wish to proceed.
Your Honor, we were going to call witnesses to discuss the procedures for the care and preservation of evidence, and then a witness or witnesses to discuss the current condition of the evidence and as discovered in December of last year.
Well, tell me this, Miss Darrell. What is the burden of proof that you would have?
I believe it would be the preponderance of evidence, Your Honor.
Has there been a case decided under the statute that you were proceeding on?
I know Mr. Clinkerson referenced cases. I pulled up, if you would allow me 1 second, Your Honor. There you go.
Well, I know that there are cases that cited, but has there been a case that's ever been dismissed?
I did not find one, Your Honor, that specifically addressed that, but I felt that 15A-268 very clearly addressed the situation and in fact stated that when evidence has been found to have been not properly maintained, that the court can and should hold a hearing relating to that and may, depending on the circumstances presented to the court, go so far as to dismiss the case. And as you know, we also have the pending motion to dismiss, and ultimately that's where we're going with this case from the defense side, Your Honor. Specifically under 15A-268, it states, if the court if the evidence that is required to be preserved is destroyed, and I'm summarizing a little bit here, Your Honor, the court may conduct a hearing to determine whether or not there has been obstruction of justice or contempt. And then further, if the court finds that the destruction violated the defendant's due process rights, the court
You put your left hand on the Bible and raise your right. Do you solemnly swear that the testimony that you should not give the court to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, sir. How are you?
Very well, thank you, ma'am.
Thank you. Would you please state for the record your name
Archie Smith.
and what is your occupation?
I'm the Clerk of Superior Court for Durham County
And how long have you been the clerk of Superior Court?
since 2002.
And did you work for the clerk of court prior to being elected the clerk of court?
No, ma'am,
But it is an elected position.
it is.
You, as the clerk of court, have certain statutory duties and responsibilities. Is that not correct?
That is correct.
The state legislature has statutes that set forth duties and responsibilities, and they also require that the clerk of court follow directives from the administrative office of court regarding the operations of the clerk's office, correct?
For the most part.
Okay. What are the responsibilities of the clerk of court's office? If you could give us an overview, please.
Well, first and foremost would be to follow the law. The clerk's offices are divided into two separate sections in terms of operation. One portion of the clerk's office is comprised of assistants and deputies that undertake ministerial duties, those that do not pertain to judicial duties. Other portions of the clerk's office pertain to judicial duties, such as presiding as the ex officio judge of probate.
When a trial is conducted in criminal court, whether, let's focus on Superior Court, the clerk of court, there is someone from the clerk of court's office present for that trial, correct?
Correct.
And their duties include what?
To keep the minutes of the proceedings.
Anything else that they are required to do?
To receive and to maintain custody of any evidence presented during the proceedings. To swear witnesses. And to do all other items required to assist the court in the administration of its duties.
And what type of training is provided to the courtroom clerks regarding their duties and responsibilities? Let's talk first just about maintaining minutes.
When an individual is employed by the office of the clerk of the Superior Court, there are various means by which training is conducted. By and large, and most prevalent throughout the state of North Carolina, is on-the-job training. That being apprenticeship, if you will. There are academic courses taught variously through the School of Government, the Assistant and Deputies Conferences, and Administrative Office of the courts.
Now, if someone is a new hire at the clerk of court's office, can they go to those conferences for assistants and deputies?
Yes.
They can. And is that done in the normal course of business in Durham County with the clerk's office?
Yes.
And is it required that they receive that training prior to working in a courtroom independently?
No.
When an individual is hired to work in the clerk of court's office, how long does their on-the-job training take?
It would depend upon the individual and their aptitude for the work.
Is there a specific program of training for the on-the-job training?
The training is tailored to the individual.
There are various regulations, as I mentioned, regarding the operations and preservation of evidence in cases, correct?
Yes, ma'am.
And those are available in your office to your employees? Are they available to your employees in the office?
It would depend on what regulations you mean, ma'am. I'm not familiar with any regulations per se.
All right. Are you familiar, sir, with Rule 14 of the North Carolina Rules of Evidence?
I am.
And that rule, first of all, establishes that the clerk of court shall be the custodian of any evidence that is admitted during a trial. Is that not true?
That is true.
And it verifies that everything should be marked as an item of evidence and that the clerk will have control of that evidence, with minor exceptions for large exhibits and such. Just usually large things that are hard to store within the clerk of court's office.
Well, the clerk's office would have custody of it, but not necessarily control. Control of the evidences would be within those parties that tendered the evidence and brought the evidence forward in terms of its use on. But the clerk's office would have the custody of the evidence.
Now, once it is admitted into evidence and the trial is concluded, the clerk's office has control. Is that not true?
The clerk's office has custody of it. That's correct. Unless and if it's returned to the party or parties who submitted it at such time as the appeal period has expired.
All right. However, under the law also, if there is an appeal, then the clerk's office has custody over admitted evidence through the life of the appeal. True?
Yes, ma'am.
if a person is convicted in a capital case and they are sentenced to death, the statute requires that the clerk's office maintain custody of the admitted evidence until that person is executed. Is that correct?
I would presume so, ma'am. I have not looked at that portion of the statute.
If a person is charged and convicted of murder and is sentenced to life without parole, do you know whether or not the clerk's office must hold in custody the admitted evidence until that person dies?
The clerk's office in Durham would retain the evidence until such times it's instructed to do otherwise.
Okay. May I approach, Your Honor?
Yes.
Sir, I'm going to show you what I marked for this hearing as Exhibit 103. And if you would review it, and then I'll ask you some questions.
Yes, ma'am.
All right. Do you see Section A6? Well, let me back up. What did I hand you, sir? Can you tell the court what you have in your hands?
You handed me a copy of North Carolina General Statute 15A-268.
And are you familiar with that statute?
Portions.
Portions of it. And that statute addresses what?
This statute addresses the custody and the maintenance of biological evidence.
And you would agree that that's an accurate copy of the statute? Well, let me back up then. Are you aware?
I can't imagine that you would give me a copy of the statute that is not a true copy, madam, and to that extent I would say yes, it's an accurate copy.
Okay. Were you aware that we had requested various documents showing the policies and procedures used in your office relating to the custody of evidence?
I recall that.
Okay. And you have counsel with you today, correct?
I do.
Mr. Ballantyne from the Attorney General's office?
Yes, I do.
And are you aware that he forwarded these regulations or procedures manual from the Administrative Office of the Courts, as well as Rule 14 and Statute 15A-268? Were you aware he sent those to us?
I'm aware that he sent you copies of the rules of record keeping, Rule 9, that likewise portions of the clerk's manual, as well as he may have provided you with this.
Okay. I'm going to ask you to turn to page 2 of that statute, or of the printout of the statute. Okay. Before I go too far, I have to ask, isn't it true that the clerk of court is considered to be a custodial agency under North Carolina statutes?
I believe it is.
Once evidence is received by the clerk of court's office, when it's been admitted, and custody, as you said, is maintained by the clerk of court, correct?
Yes, ma'am.
And under statute, the clerk of court's office becomes the custodial agency.
I believe so.
Okay. And on the second page of the statute for 15A-268, It discusses how long evidence should be maintained in a case, correct?
If you'll give me the section that you're looking at, there's a number of sections here.
Okay.
Please tell me which section you are referencing. I'll be glad to read it.
Actually, let me refer you back to page 1, A1. Would you read that clause, please? A1.
Notwithstanding any other provision of law and subject to subsection B of this section, a custodial agency shall preserve any physical evidence, regardless of the date of collection, that is reasonably likely to contain any biological evidence collected in the course of a criminal investigation or prosecution. Evidence shall be preserved in a manner reasonably calculated to prevent contamination or degradation of any biological evidence that might be present, subject to a continuous chain of custody, and securely retain sufficient official documentation to locate the evidence.
Regarding that, what steps are in existence and have been in existence with the clerk of court for maintaining evidence from cases? And I'm going to ask you to go back, if you can, to 2003 and move us forward. Because I believe in 2003, evidence was maintained at the jail.
In 2003, the top floor of the courthouse was the floor upon which Durham County used to have its jail. The evidence was kept on that floor for some evidence. Evidence was likewise kept in evidence lockers / closets on the floor where the Superior Court is located.
Very well. Was there a log maintained regarding where the evidence for the various cases was being kept?
The logs were maintained by the assistant clerks of court for their use in finding the evidence, and that would be an inquiry more properly directed to one of them.
All right. Well, if they maintained it, was it done, did the various assistants have sections of court that they were responsible for maintaining those logs for? Or was there one assistant responsible for all of the logs? How was that assigned within the office?
The logs for the evidence was maintained by the Superior Court section of the clerk's office under the direction of the assistant and or assistants in that division.
When these logs were created, were there logs just documenting where the evidence for various cases was maintained, so that you could look and say, in this instance, I would like to see the evidence in the Michael Peterson case. Oh, I need to go to cell number 1.
If your question is, was there a log that would direct an assistant clerk of court as to where the evidence in this case was kept, I can tell you that this evidence was kept in only one place.
But if there was a change in personnel, how would they know that it was kept in one place?
Well, ma'am, there wasn't a change. I mean, that's a speculation, ma'am. I suppose they would tell each other.
All right. There's no written procedure then for how the log is shared between the employees?
I'm sure that there is, but that'd be a question more properly addressed to the assistant clerk of court who handles that division.
Is the log, do you know if there is one log that is maintained in one place and each assistant goes and inputs their data into that master log?
That's a question you'll have to ask that assistant clerk of court.
Very well. Now, for the individual pieces of evidence, is there, in a case, a specific case, is there an inventory maintained of all the items of evidence?
The assistant clerk of court or the deputy clerk of court who is in the courtroom at the time the case is being tried marks on their minutes as an item of evidence is introduced, and it is kept in the minutes.
Do they separately create, separate from the minutes, a log sheet just identifying each item number and what it is?
I cannot answer that.
You said that in 2003, at the top of the court, on the top floor of the courthouse, there were jail cells, and that's where the evidence was maintained. While it was there, was that an air-conditioned or any type of climate-controlled floor?
Insofar as it was used to house inmates at one time, I'm confident that there was heat and air available. As to whether or not it was kept at a set temperature is a question I cannot answer.
Okay. Are you aware that at some point in time there was a water leak up there and many items were waterlogged or perhaps damaged because of the leak?
I don't recall that.
Okay. When was that, when were all of the exhibits and evidence that were in the custody of the clerk's office moved out of the old courthouse?
Upon the occasion of moving to the new facility where we are today.
And do you recall what year that was?
2 years ago, 2013, 14.
Okay. And what procedures were used to move that evidence?
Each individual assistant clerk of court was responsible for the gathering together of the information, properties, files, equipment for his or her division, and for boxing and preparing same, and oversight for the transportation of those materials underneath his or her control to this facility.
Did they specifically move those materials themselves?
No,
How was that done?
a moving company.
And what procedures were used to ensure that the moving company appropriately or used appropriate care to move those exhibits to the new building?
The evidence was removed by the moving company underneath the supervision and oversight of the Durham County Sheriff's Office.
What if a clerk had moved to a different position or left the office? Who handled the evidence that they had previously boxed up and stored?
I'm sorry, ma'am, I don't understand your question.
You said that each individual a clerk of court was responsible for boxing, preparing the evidence in preparation for the move, the evidence that was assigned to them. So let's say in 2003 there is a clerk of court who was present during the Michael Peterson trial and prepared the evidence, accepted the evidence, boxed it up, stored it in the old courthouse. But that clerk moved on to a different assignment. who was then responsible for ensuring the proper removal and replacement in this building of that evidence?
Or in the event that the deputy clerk or assistant clerk who sat at the trial, gathered the evidence, placed it in the boxes, was no longer in that division, it would be anyone in that division whose hands were available and time was available in order to move the evidence. The evidence was not assigned to any one deputy or assistant clerk. It was the property of the clerk's office.
Correct. But all Superior Court clerks were jointly responsible for the proper removal of that evidence? Or packaging so it, or preparation of it so it could be moved by the moving company?
The Superior Court Division was responsible for the moving of it. As to how the assistants in that division delegated responsibility to deputies or to themselves as to who will actually touch, pick, remove, physically transport, or do is a question I cannot answer because the assistant clerks were, that responsibility was delegated to them and I was not present when it was done.
Okay. Did your office require, though, that they maintain logs as to who touched which boxes of evidence in preparation for the move?
I don't believe we did.
Fair enough. Now, what rules and regulations or policies and procedures does your office have specifically for the maintenance of evidence that is in the custody of the clerk of court?
We follow Rule 9 of the North Carolina Rules of Record Keeping, which direct us to Rule 14 of the rules governing the practice of law in the Superior and District Court divisions.
Very well. In reviewing Rule 9, I don't see any regulations or I don't see anything addressing in either Rule 9 or Rule 14 climate control, pest control, the requirement for logs being maintained and inventories. Would you agree with that?
I would say that the rule and the statute speak for themselves.
Very well. Have you reviewed the rule and the statutes of late?
I have.
Pardon me?
I have.
Okay. And did you see anything in the rule or the statutes setting forth the required procedures for maintaining exhibits or evidence that is in the custody of the clerk of court?
No.
Okay. Now I'm going to ask you to move to the second page of that printout of 15A-268. And I'm going to refer to A6.
Yes, ma'am.
Okay. Are you familiar with the Michael Peterson case?
I am familiar with it in the sense that it was a case that was tried in Durham County. I never attended court during the conduct of that trial.
Very well. But you are aware that Mr. Peterson was convicted in 2003?
Yes, ma'am.
Okay. Of first-degree murder?
Yes, ma'am.
Okay. His sentence was a sentence of life without parole, which is a statutory required sentence in first-degree murder, correct? If you know? Will you accept that from me?
I'm not a criminal lawyer.
Very well, okay. In A6, it talks about the length of time that evidence is to be maintained in various types of cases. For instance, Evidence shall be preserved for the following period. 1, for conviction resulting in a sentence of death until execution. Do you see that? That would be A6.
Yes, ma'am, I do.
Okay. And then 2, for conviction resulting in a sentence of life without parole until the death of the convicted person.
Yes, ma'am.
Do you see that?
Yes, ma'am.
Now, in certain situations, evidence may be disposed of after the appeals have been concluded, correct?
Yes, ma'am.
But when there is a death sentence or a life sentence, the clerk of court must maintain that evidence until the death of the defendant. True?
That's what the statute reads.
Does your office have any policies or procedures to ensure that evidence is maintained over that period of time until the individual passes?
We would not discard the evidence. The evidence would be maintained in the packaging in which it was left at the time the trial was concluded.
Okay, thank you. When evidence is received during a trial, what, if you know, if any requirements are there for the packaging of that evidence before it is moved to storage?
I'm not aware of any requirements as to packaging.
Okay. Is there any requirement or is there any training within your office relative to paper evidence versus physical evidence?
Not that I'm aware of.
Are there any special procedures in your office that you're aware of relating to the preservation of biological evidence, such as DNA, blood, fingerprints?
We are aware that under 268, if we are instructed by a court to preserve evidence as biological evidence, that we should comport ourselves in accordance with the SBI guidelines promulgated in approximately 2007.
Okay. Is there any specific training done in your office relative to the handling of biohazardous materials that are in evidence?
Not that I'm aware of.
Okay, thank you. When your employees come on board, are they asked, I think I asked you a portion of this question, are they provided with copies of Rule 14, Rule 9, the Administrative Office of the Court's manual regarding handling of evidence?
I'm not aware of that being done. The proper person or persons to address that would be either the assistant who is serving as a mentor, the deputy who is serving as a mentor, and or the instructors in any classes that train them.
So there's not one person in your office designated with the responsibility for training the clerks relative to the preservation of evidence?
No, ma'am.
Okay. Do you know whether or not when an individual completes their training, they are asked to sign documentation saying that they've had or been provided these documents?
No, ma'am.
Okay. No further questions.
Cross-exam.
Thank you, Your Honor. Mr. Smith, as far as items of evidence that are offered and are then placed in the custody of the clerk of court, if there is a an order of the court, some of those items go to the Court of Appeals.
Pardon me?
Well, some of those items, if there is a conviction, and certain items are maintained in the custody of the clerk of court, as a result of either being offered or introduced into evidence, will some of those items be transferred to the Court of Appeals if there is an order of the court?
Yes.
And do you know whether or not it's the clerk's office's responsibility to retrieve those items, or do you know whether or not it's the parties?
Once items have been transported to the Court of Appeals, until such time as they are returned to us, they're out of our chain of custody, and we have no further inquiry into that.
Okay. And as far as items that are maintained within your custody after trial, that was some of the things that were being discussed. If an item is of evidence that has been introduced or been offered and is therefore in the custody of the clerk within the courtroom, does the clerk have the trial itself as the trial is underway, as far as how the time of when Mr. Peterson's trial occurred, the statute that we're referencing, 15A 268, that was not in the same form that is presently in and has been submitted to you. Is that correct?
No, sir, it was not in the form that it is now.
It was amended in 2007. Is that correct?
I think that may be correct, sir.
And in fact, much of the statute as it currently exists did not exist within the wording back in 2003. Isn't that correct?
Well, sir, I'd have to compare the two, but I know that there's substantial differences as to requirements of evidence and the maintenance of it, particularly as relates to guidelines promulgated by the SBI.
And when were those guidelines promulgated?
2007.
And counsel had you read a portion of the statute. Could you read to us subsections A3 and A4?
When physical evidence is offered or admitted into evidence in a criminal proceeding of the General Court of Justice, the presiding judge shall inquire of the state and defendant as to the identity of the collecting agency of the evidence and whether the evidence in question is reasonably likely to contain biological evidence, and if that biological evidence is relevant to establishing the identity of the perpetrator in the case. If either party asserts that the evidence in question may have biological evidentiary value, and the court so finds, evidence be so designated in the court's records, and that the evidence be preserved pursuant to the requirements of this section. That is A3. A4, evidence has been designated by the court as biological evidence pursuant to subsection A3 of this section. The clerk of superior court that takes custody of evidence pursuant to the rules of practice and procedure for the superior and district courts as adopted by the Supreme Court pursuant to Rule GS 7A 34 shall preserve such evidence consistent with subsection A1 of this section. Upon conclusion of the clerk's role as custodian, as provided in the applicable rules of practice, the clerk shall return such evidence to the collecting agency as determined in subsection A3 of this section in a manner that ensures the chain of custody is maintained and documented.
Are you aware of any instructions or any party requesting a court's instructions pursuant to A3 as you just read it into the record?
No,
To your knowledge, has the clerk's office ever received such instruction?
no,
And within the clerk maintains not only the evidence, but also the court file, is that correct?
it is.
And are you aware as to whether or not there's any such instructions within the court file as well?
Not to my knowledge.
Now, you mentioned that within the court file, there would be minutes documenting items of evidence that are offered or introduced into evidence, is that correct?
Yes, sir.
And if a defendant was to make a written request for an inventory of the items that have been introduced in evidence pursuant to A7 of this statute, could the clerk's office provide, upon referencing these minutes, an inventory of the items that were collected and maintained within the custody of the clerk's office?
Yes,
And have you received such a request? To your knowledge, have you received such a request?
I've received numerous documents, but I haven't personally, as the elected clerk, been responsible for providing such a list.
Are you aware of any items of evidence that are not accounted for, that being they either
No, sir.
are not in the custody of the clerk of superior court, or they haven't been sent off, and also haven't been sent off to the Court of Appeals?
Mr. Dornfried, if the clerk's office is asked to provide a piece of physical evidence involving this case, we will either have it in hand and available or can make it available.
Thank you. I have no further questions of this witness, Your Honor.
So, sir, are you, through the questions you were asked by Mr. Dornfried, are you trying to say that your office had no responsibility for the evidence in the Michael Peterson case?
No, ma'am.
Okay. And did anybody from your office ask the collecting agency, which I presume would have been Durham Police Department, to take back the evidence?
Pardon me, would you repeat the question, please, ma'am?
No one in your office asked the Durham Police Department to take the evidence back, correct?
No, ma'am.
And in truth, you really couldn't, because, first of all, it was in your custody as the custodial agency. You could not waive that, correct?
That's correct.
And you had to hold it, the clerk's office had to hold it until the death of Michael Peterson.
That's my understanding of the statute.
Okay. And so that evidence was maintained until 2014 because of the pending charges. I mean, because of the conviction. And then since 2014, it has been maintained because a new trial was granted, correct?
Yes, well, ma'am, as to the reason as to why we're maintaining it, I won't make any differentiation on any portion of that except to say we will not discard, have not discarded, have not even anticipated discarding any evidence regarding this proceeding until we are instructed to do so by competent authority.
Very well. And it's your testimony that you have no independent knowledge or personal knowledge of how that evidence was stored or prepared for storage, correct?
No, ma'am.
Thank you. No further questions.
No questions, Your Honor.
You can come down.
Thank you, Judge Hudson. Thank you, folks.
Ask the witness be released, Your Honor.
Certainly. No
All
objection.
right. All right.
We next call Angie Kelly to the stand.
Now, please put your left hand on the Bible, raise your right. Do you solemnly swear that the testimony that you should not give before to the truth, the whole truth, and nothing but the truth, so help you God? I do. You can be seated.
Good afternoon or morning. Would you state your name for the record, please?
Angela Kelly.
And how are you employed?
I'm employed here as in Superior Criminal Court as an assistant clerk.
Okay. How long have you been an employee of the Clerk of Court for Durham County?
29 years.
How many?
29.
What positions have you held in the Clerk of Court's office?
Deputy clerk and assistant clerk.
What is the difference between a deputy clerk and an assistant clerk?
The deputy clerk is our starting position. Assistant clerk is supervisor.
Okay. You are currently in the criminal section?
I am.
Have you always been in the criminal section?
No.
Okay. What other sections have you worked in?
Also was an assistant in district criminal court.
Okay. So you've been in district and superior court?
Correct.
Very well. Over the years, what, if any, training have you received regarding, well, let me ask this, first of all. We're going to discuss superior court primarily. My questions will be geared toward that. Is that acceptable to you?
Yes.
And as the clerk of court in superior court, were you a deputy or an assistant?
I've been both.
Been both, okay. In 2003, when the trial of State versus Michael Peterson was conducted, were you the clerk in superior court that was present for the trial?
Yes, I was. I was the deputy clerk at that time.
You were the deputy clerk then, okay. And there was a lot of evidence in that case, correct?
Correct.
And you were responsible for securing the evidence as it was admitted during the trial?
Correct.
If you know approximately, how many boxes of evidence were there when the trial was concluded?
I would say maybe 8.
80?
8
8.
boxes. There was a lot of large pieces that were not boxed.
Those were things such as exhibits and graphs and blown up photographs, correct?
Correct.
Very well. What type of training did you receive regarding the handling of evidence when it was received by you in the courtroom?
I received training through my previous supervisor as well as previous Superior Court judges.
Judges?
Judges. Also, if there was a class available through AOC, and it was on-the-job training.
Let's talk about the classes at AOC. Approximately how often did you attend such classes?
I have no idea. I mean, that's been years. Whatever was available that would help me in my area is, you went to the class.
Would it be, could you estimate? I mean, have you been to maybe 10 classes or 5 classes or 20?
Over the years, I've probably been to, I would say 15 or more.
Okay. Now, they weren't all geared toward how to process or package evidence.
Correct.
When you received your on-the-job training, what were you taught regarding exhibits that were in specific types of packaging?
To do my best to put it in that same packaging.
Were you present at trials where packages would be cut open with scissors?
Yes.
And those packages that were cut open with scissors, what would you do after you received them?
I would put it back in its package as best I could.
Okay. If during the course of a trial, as sometimes happens, you had packages that were torn open, is that not true?
Correct.
What did you do with those?
Again, put it back in the packaging as best I could.
Okay. Did you ever did you have to mark those packages as being received in evidence?
No,
So you didn't have to put any marking on the outside of those packages,
no, it was put in my minutes.
in your minutes only. Did you understand the markings on the outside of the packages when you would receive them?
I would, because it would be marked by exhibit number.
By exhibit number.
Yes,
And it was not uncommon for some packages to have tape on it, or initials, or case numbers, correct?
correct. It was previously done before I received it.
Right. Typically by the police department or sheriff's office, whoever was investigating the case.
Correct.
Okay. Do you know why they would do that?
That was their way of maintaining evidence, and then I had my way.
Okay. Are you familiar with the term chain of custody?
I am.
Okay. And I assume, if you will verify this for me, that you have heard that many times in the course of trials.
Yes,
Law enforcement uses that to keep track of where evidence was collected and every person that touched it. Is that not true?
that's my understanding.
Does the clerk of court's office have any such procedure for maintaining the chain of custody once the clerk receives the evidence?
We have our minutes, how we are able to explain, as well as at the end of the trial, the Durham Police Department has a form that we sign to keep within the file.
And what type of form is that?
It's from the police department stating what they have given us, and we make sure that's what we have.
And if there are pieces of evidence that are introduced at trial that came from the attorneys, for example, instead of the police department, is there any type of, other than the minutes, any other documentation of what there is?
No,
When you have a large trial, such as the Michael Peterson trial, and you have many boxes, what do you do with the boxes to identify what trial they belong to?
the name is on each box.
Do you keep the case number on the file?
Yes. And
What
that's
else,
normally
on the box, excuse me?
That's usually done at the end of the trial.
Very well. And that's reasonable because the evidence is used throughout the trial usually, true?
Correct. Yes.
Okay, so let's go forward then to the end of the trial. The Peterson trial lasted for a very long time, did it not?
It did.
What did you do with all of that evidence at the conclusion of the trial after the verdict was returned?
It was taped and sealed and put in to evidence
Okay.
under
What was taped and sealed?
the boxes.
Okay. And what did you put on the outside of the boxes, please, again?
The name, the file number, and I also had, if it was defense or the defendant's evidence, I had it separated in boxes.
So you'd have state evidence, defense evidence.
Correct.
Okay. Did you put on the outside of any of those boxes a list of what items were contained inside?
I did not.
Is that anything that has been done in your 29 years with the clerk of court's office?
No.
Do you put a list of what contents are in the box, inside the box with those exhibits?
I do not.
Do you keep a separate log, separate from the minutes, or inventory of the exhibits, the evidence on, on your computer or in a log book, so that you can look and say, I need to go to box 3 for this particular item?
I do not.
Do you keep a separate log, separate from the minutes or inventory of the exhibits, the evidence on your computer or in a log book, so that you can look and say, I need to go to box 3 for this particular item? to find the sneakers?
No,
So if someone requests the opportunity to look at the photos from a crime scene, you would have to go through all of the boxes to locate them?
yes,
Okay. Do you maintain a log of who comes in contact or views the exhibits after the trial?
yes.
And how is that maintained?
It's written on my calendar.
On your what?
Calendar.
Okay. So at some point in time in this case, the Court of Appeals requested various items of evidence, true?
Correct.
Were you still working in Superior Court when they requested that?
The first request, yes.
And what did you do to take that evidence out of the boxes of evidence you had?
I don't understand. What did I,
How did you locate the evidence that the Court of Appeals requested?
I went into the boxes and pulled by exhibit numbers that were requested.
Did you prepare anything to document that you were the person that took it out and who you gave it to?
It is.
Okay. And where did you keep that?
It's in the file.
In the case file?
Yes.
And who did you give those exhibits to after you pulled them?
It's on that paperwork. I don't recall the name of the person that received it, but the paperwork was signed that they received it.
Would you have been the person that brought those exhibits to the Court of Appeals?
It was I and David Sachs from the District Attorney's Office.
Did you have Mr. Sachs sign anything acknowledging that he helped you move those items to the Clerk of Court, to the Court of Appeals?
From what I can recall, Mr. Sachs' name is on that paper as well. Everybody signed off that it was taken to them, what exhibits were taken, and who received it.
Okay. Now, it's my understanding that over the years, you may have been requested to allow different people the opportunity to look at the evidence.
Yes.
What procedures did you use when a person viewed the evidence?
It was viewed wherever one of us were there. They were never left alone. And we also provided gloves. And we sat with that person until they finished. And then it would be packaged back and put back into evidence.
And who would package it back and put it back in evidence?
The clerk.
Who moved the exhibits and the evidence up to the top floor of the old courthouse?
I did, and possibly help from another clerk.
But if someone helped you, you were there to
Oh,
make
yes.
sure it all went, okay. And where or how was the evidence in the Peterson case maintained after the trial? Where was it
It
stored?
was stored in a jail cell, a single jail cell.
And why was it in a single jail cell?
That was a place that was available for superior criminal, and it was also perfect to have all evidence together.
Did you participate in the move from the old courthouse to this courthouse?
No, I did not.
You were working here, though, at the time.
Yes,
What was your assignment at that point in time?
I was then working in district criminal as an assistant.
Oh. So do you have any personal knowledge of how the evidence from the Michael Peterson case was moved from the old courthouse to this courthouse?
I do not.
How is it maintained in this courthouse?
It is under lock and key in a room, evidence room for superior criminal cases only.
Is there one large evidence room for all the evidence that's been admitted over the years for all the cases?
It is. We have two. We have one on the second floor. We also have one on this floor.
Is there a logbook there to show where evidence for a certain case is maintained?
It is.
And that logbook is kept where?
In the evidence room.
Okay. So if you were to go in to look at the evidence in the Michael Peterson trial, you would go and check in on that logbook with the date and time, signing your name and saying which evidence you were going toward or to review?
No, I'm just able to look on, go in the evidence room, look and see where it is located within the evidence room and go straight to it
Okay.
as to what shelf it's on.
Are the evidence rooms here better organized than they were at the old building?
Very much so.
And are they, is the climate better for maintaining evidence?
It is.
What was it like in the top floor of the old courthouse? Was there any heat or air conditioning going typically?
It was just normal. It wasn't hot, it wasn't cold, and it was in a cell by itself, so it just kind of maintained the same temperature as I entered.
Okay. You were not aware of any of the evidence being damaged while it was in that cell, correct?
No.
Were you aware of anybody accessing that evidence while it was in storage?
No.
Now, in December of last year, you were asked to retrieve the evidence from the case for a viewing by the attorneys, correct?
Correct.
And so you would have gone to the evidence room, one of the evidence rooms here in the building?
Yes.
And was there, when you retrieved those boxes, did they appear to be in the same condition as when you had last taped and sealed them?
They appeared to be a different box.
Okay. What type of different box?
Just that the handwriting was not mine and the boxes appeared to be different. When we moved, we had certain boxes that we had to use and it appeared to be those boxes.
And, okay, so this looked like newer boxes.
Yes.
And who was responsible for moving evidence into the new boxes?
I do not know. I was not there.
Were there any markings on the outside of those boxes that would say who packaged them?
No, not that I'm aware of.
Was, have you inquired as to who might have repackaged those?
No, I have not.
Was there a log or an assignment chart issued saying this clerk, you know, Angie Kelly, you are responsible for moving all the boxes in this cell, and another person's responsible for moving the boxes in another cell? Was there any type of assignment done specifically for the clerks?
Not that I'm aware of.
Do you know who was responsible for the moving of the boxes?
I am not
Now, in December 2015, a number of attorneys came to look at the evidence, true?
Yes.
Mr. Darnfried and Ms. No, yeah, and Mr. Klinkenson
Yes.
came? Okay.
And others.
And I came.
Yes.
I think Ms. Gladden came at one point. Do you remember seeing Mr.
Yes.
Hendrick? And Kelly, I'm sorry, I forgot your last. Granger? Do you remember her being there? Okay. And while we examined the evidence, you brought it out and the boxes would be opened and examined.
Yes.
Did you examine any of those boxes prior to our viewing?
No.
Okay. We came out on 2 occasions, December 3rd and December 16th. Would you agree with that?
Yes.
Did you learn at some point in time that there was evidence from other cases mixed in?
It was brought to my attention and given to me.
Okay. Were you still working in Superior Court? Well, you were in Superior Court through 2003, correct?
I'm back in Superior Court, yes.
Are you familiar with one Jacinto Barr?
I recall that name.
Do you recall whether you worked on that trial or
I
not?
do not.
Would you be surprised to know that police reports from his case were included in the Michael Peterson files or boxes of exhibits?
What's the question?
Would you be surprised to learn that exhibits from the Jacinto Barr trial were located inside one of the boxes of evidence in the Michael Peterson case?
Yes,
Why?
because we boxed evidence for each case. There should not be mixed.
Were you aware that photos of a deceased individual, not Kathleen Peterson and not related to the Jacinto Barr case, were also located in the Michael Peterson boxes?
Yes,
Okay. Do you know how they would have gotten in there?
I do not.
Okay. What training have you had on the handling of evidence that's been marked as biohazard?
Haven't had any training, but if something was to be done, I would be ordered by the court.
Pardon me?
I would be ordered by the court if anything needed to be done different than others.
So the label of biohazard would not cause you to independently take specific steps regarding the care and handling of that
I would
evidence?
just keep it all together, how
What do you do when you receive an object in evidence where the bag has been torn almost to the point that you can't even put anything in it because it's wide open? Is there anything you do or have done to make sure that the exhibit stays in the packaging?
no more than a piece of tape, maybe, but other than that, no.
So you wouldn't take it and put it inside another bag just so it could, so the wrappings and the exhibit could be all in one place but contained?
No.
Would not do that. Okay. Are you aware of any other clerks of court offices doing such things?
No.
Okay. Do you ever have occasion to do the clerk of court's offices interact or ever consult with each other on the handling of evidence and best practices?
I have not.
Does your office conduct any in-house training, such as in-house seminars for the employees on best practices and latest rules for handling evidence?
Not that I'm aware of.
Do you recall ever receiving any in-house training, not on the job, but such as just a seminar where the supervisors say, okay, on Friday at 3, we're all going to meet and we're going to review how to maintain logs or how to maintain box up evidence, anything like that?
No.
You said that the boxes were different when you went to retrieve them last December. Did you open them after you moved them out of the evidence room?
No.
So you did not look at them prior to any of the attorneys coming to review the evidence?
No.
Did you know why they were coming to view the evidence?
I assumed.
And what did you assume?
Just to be viewed since there was a new trial.
Right, for the new trial. Very well. Let's see. One second, please. Just a few more questions. You didn't reseal every item of evidence that was submitted during the trial?
At the time of the trial?
Right.
I'm sorry, your question is?
You didn't reseal them?
Each piece of evidence?
Right. If a bag that contained evidence was presented to you as an exhibit and the bag was torn, did you take any steps to reseal them?
No.
No take. And when you went to retrieve the evidence for the Court of Appeals, did you wear gloves?
For the outside of the box? No.
What about the inside for the items that the court requested?
No. I only use gloves if I'm going inside of the box.
Okay. But I assume you had to go, did you have to go into the boxes to get some of the items that the Court of Appeals requested?
Oh, yes.
Okay. Did you wear gloves when you did that?
Yes.
Did Mr. Sachs wear gloves when he did that?
Yes.
How were those items packaged after they were retrieved and before they were brought to the to the Court of Appeals?
From what I can recall, they were put in a box. Depending on what it was, I think pictures were in a manila envelope. I mean, it's been so long. I'm sure it was in a box. And then there were posters that were just carried because we weren't able to box them.
Were there ever any exhibits that you placed in the boxes that did not have bags, either paper or plastic, around them?
I don't recall. I mean, it's been a long time, but I can't honestly say, but I would assume that they were I'm pretty sure they were in a bag or however they were received.
However they were received. And may I approach, Your Honor?
Yes.
I'm going to show her some of these. I'm not sure which ones. Not all of them, I promise. It's going to be more the ones with the packaging on them. So that, to try to get it identified. I'd like to show you some exhibits. This one is marked 13. I'd ask you to look at it. And if you could describe what you see there.
Exhibits from the Peterson case.
And are there any items in there that are not completely enclosed or contained?
Yes.
And they are what?
A pair of tennis shoes and a piece of clothing.
Okay. And is there anything about that clothing that is unusual compared to something somebody would walk down the street wearing? What does it appear to have on it?
Bloodstains.
I'm going to show you our exhibit 22, and ask you if you can explain what that reflects.
Looks like a bag or
Okay. And is the bag in, what type of condition is the bag in?
it appears to have been cut.
And does it appear to have been sealed at all? Resealed?
Possibly.
Show you exhibit 23. Ask you to look at that. What is that?
A manila envelope.
And is there anything identifying the contents of that manila envelope?
It's a card on
Pardon me?
it. A card.
Yes, and what does it
Property
say
card.
that it contains?
Hair samples.
And does that envelope appear to be fully sealed?
No.
Um, I'm going to show you now Exhibit 30, our Exhibit 30, and ask if you can describe what is in that photograph.
Picture of someone holding a bag with gloves on.
Does the bag have any markings on it that you can see?
No.
And I am next going to show you our Exhibit 38 and ask you to look at that. What does that reflect?
A box with evidence in it.
And one of those exhibits is marked Exhibit 11A.
Yes.
Okay. And it appears that it was in a bag,
Yes.
but the bag was not resealed, correct?
Correct.
Are there other exhibits touching that exhibit?
It is.
Are those exhibits touching the contents of that bag?
I'm not sure. The depth between the two, just looking at the picture.
And I'm going to show you last Exhibit 32. Ask you to look at that. What does that reflect?
Evidence in a box.
What type of evidence?
A pair of tennis shoes, and it appears to be some clothing.
Okay. And are the tennis shoes fully within the bag, the evidence bag they were in?
As best it can. It looks like it's
As
been
best
cut.
they can. Okay. So it's, but at least the top half of the shoes are exposed, true?
The back half of the shoes.
Yeah. And the piece of clothing underneath it, is that, can you see any marking or identification or wrapping on it?
No.
Okay. Would that be consistent with the way you place things in the bags to begin with? The boxes, excuse me?
No.
No. What would the difference be?
They would be in the package
Okay.
as best it could be.
All right. So, let me show you Exhibit 14. Would they be more like that?
I would think so.
That's a photograph of the shoes, better packaged, correct?
Correct.
Okay, but they're not fully covered and contained, true?
True.
But that would be consistent with how you place things in the boxes.
Yes.
Thank you. I have no further questions, Your Honor.
Ms. Kelly, you mentioned that there were some logbooks relating to the boxes of evidence in the Peterson trial. Are these inventory logbooks that would tell you what was kept as opposed to visitation logs? Do you understand my question?
No, I don't.
Okay. You mentioned that there were some logbooks. Do you remember talking about that?
Yes.
And would those logbooks detail the items of evidence that were kept in a location?
It referred to what was in the closets, or are you referring to in, what were kept in the closets
Okay.
of evidence that we had at the old courthouse?
So would these be like inventory logs?
Not inventory, just the name.
Okay. So it would tell you the name of the case that would be present within that particular evidence room? Is that correct?
Correct.
Now, you mentioned that the evidence in regards to Mr. Peterson's case, that was kept in a jail cell, is that correct?
That's correct.
And you mentioned it wasn't too hot, it wasn't too cold, did it seem to be the same temperature as on the other floors of the courthouse?
Well, not as cold with air conditioning and the floors we were in, but it was always comfortable. It was no problem for me to go in.
And the cell, was this locked?
It was
And do you know how many keys there were for that particular cell?
one.
And where was this, who maintained custody of that key to your knowledge?
The clerk's office.
You know where it was kept?
It was kept locked in another cabinet.
Now, when did you transfer to the district court division? Do you recall?
I think it was 2012.
And do you recall when you went back to the Superior Court division?
No, I want to say end of 2013
Or were you in the new courthouse at that point in time?
when I returned back.
Yes, ma'am.
Yes.
From 2003 to the time that you moved to district court in 2012, were you practicing within the Superior Court Criminal Division?
Yes.
And when did you become a supervisor within that division? Do you recall?
I think 2007.
Prior to your transfer to the district court division, was there any one particular person who was assigned to handle any matters related to the Peterson evidence?
There was no one assigned to it, but I was mostly asked because I was familiar with it.
Okay. And you mentioned on direct examination that no one was accessing those items while it was in storage. By that, do you mean that no one other than the clerk's office?
Correct.
And there were certain occasions where people were asking for the opportunity to view certain items of evidence. Isn't that correct?
I'm sorry.
There were certain occasions when individuals were asking for the opportunity to view certain items of evidence as related to the Peterson case.
Yes.
And when that occurred, did you assist these individuals in retrieving items?
Depending on what items they needed, sometimes I was able to go and pull those items if they were specific.
Okay.
And then there were times I had to sit with whomever.
All right. And as far as to sit with individuals, when items were being taken or being pulled from the boxes for the first time the matter went to the Court of Appeals, you indicated that you were with Mr. Sachs and you pulled items out of the respective boxes in order to prepare these items for transport?
Yes.
And you stayed with those items the entire time from that cell to the point where they were delivered to the Court of Appeals, is that right?
Correct.
And as far as other occasions, do you recall an incident when there was a request to see a slide by Attorney Pollard in which a law enforcement officer would also be present to take a look at a particular slide? Do you recall that?
I do.
And on that occasion, would that officer be Art Holland?
Yes.
And were you present when the box containing this slide was recovered from the jail cell?
Yes, I removed the box from the jail cell.
And at that time, when you retrieved, did you actually take it out of the box?
I actually just brought the box.
Okay. And at that point in time, were gloves provided for any individuals who are going to be examining this particular slide?
Yes, there was a box. I always bring my gloves with me.
And Detective Holland was present, Attorney Pollard, and there's also an expert there that had a microscope, is that right?
Correct.
And you were present the entire time?
I was.
And after the examination of this one particular slide, did you then take custody of that slide and put the items back in the evidence box in the locked cell on the 7th floor?
They returned the slide to the box, and then I took the box back to evidence.
And the entire time, did you insist that they were wearing gloves?
Yes.
And do you recall, were there other occasions when other individuals asked to see some of the evidence in the Peterson case?
No more than during the trial when evidence was looked at through, when they were filming.
Okay. And would that be at the end of business, but prior to 5 o'clock, between 3 and 5 o'clock, that you would show the evidence that had been introduced that day?
Correct.
And would the individuals that these items of evidence would be shown to, were they actually manipulating the items, like moving them around, or did you ensure these items are being placed in a certain location and then put back into whatever evidence box or bag?
Correct. When they wanted to take a picture of that particular piece of evidence, I would make it available with my gloves on. They take their picture, I put it back.
Okay. And so you made sure that you wore gloves as well?
Yes.
And was there a reason that you were wearing gloves and insisted other people wear gloves?
Yes.
Why?
That's what I've always been told. You wear gloves to, no fingerprints, no contaminate.
Now, as far as the trial itself, introducing the evidence, and that attorney would handle those items,
I did not dictate, no.
did not wear gloves and was handling these items of evidence, you would not have control over him, is that correct?
Correct.
If Attorney David Rudolph was commingling and mixing up different items of evidence and putting, and you mentioned that at the end of the individuals who were filming these proceedings wanted to take, I guess, close-up pictures of these items of evidence, is that correct?
Yes.
So this trial was being filmed, isn't that right?
Yes.
So we could see on the film how Mr. Peterson's attorney was handling these items of evidence that we're talking about here today. And this is prior to any of these items going up after the verdict to the storage room on the 7th floor.
So,
Thank you. No further questions, Your Honor.
So, Ms. Kelly, you've been through many trials over the years, correct?
yes,
You've heard much testimony about DNA.
yes.
So if Mr. Rudolph, while handling an exhibit, got some of his DNA on it, that could happen, right?
It could.
But if somebody needed to test one of those exhibits further to see whose DNA was on it, we could get Mr. Rudolph's DNA and make sure that if his was on it, it could be identified, correct?
I would assume so.
Thank you. No further questions.
For Mr. Rudolph, do you know who he shook hands with before if he did handle these items with his bare hands?
No, I don't.
If you put these items down on a table or on a bench in front of a witness, do you have any idea whether or not that bench had been cleaned prior to those items being put on the bench?
I do not.
Do you have any idea who else's DNA may have been on that bench at the time that Mr. Rudolph was placing these items without any coverings on this bench?
I do not.
And do you know whether or not DNA was being transferred from one item to the other when Mr. Rudolph was putting them in the same bag?
No, I do not.
And do you know whether or not DNA was being transferred as Mr. Rudolph was moving from one item to the other without washing his hands and not wearing gloves?
I do not.
Thank you. No further questions of this witness.
Briefly, Your Honor. Assistant District Attorney Freda Black was also touching evidence without gloves, correct?
Honestly, I would assume. I don't know.
And Detective Holland was touching it without gloves while he was testifying?
I don't recall. I mean, I don't know.
Okay. But in truth, in the courtroom, the evidence may not have been well handled, correct?
That's a possibility.
But what we do know, even from the pictures I showed you, is that the evidence was not sealed in such a way when it was stored as to prevent any cross-contamination as well. True?
I assume by it being open that no, it wasn't.
Thank you. No further questions.
No questions, Your Honor. Ask the witness be released, Your Honor.
All right.